Hello everyone, welcome to Legal Darshan. In this video, we are going to look at case number 35 in the list of AOR leading cases. And the case is titled as Shreya Singhal versus Union of India 2015 5 SCR 963. Now, this case, we all know it relates to IT Act and specifically deals with striking down of provision contained in Section 66A of the Information Technology Act. Now, in this case, the challenge was raised to three provisions of the IT Act. One is Section 66A, one is Section 69A, and another is Section 79. Now, let's read first. Let's know what the sections are. So, Section 66A is any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has menacing character or information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will persistently by making use of such computer resource or a communication device, any electronic mail or a message for the purpose of causing annoyance or inconvenience or to deceive or to mislead the addressee or recipient about the origin of such message shall be punishable with imprisonment for a term which may extend to 3 years and with fine. Now, if we go by the heading, a simple heading says that if you send offensive or menacing character messages to any person through communication services, then you shall be punishable. Now, what is offensive and what is of menacing character, or what may cause annoyance, inconvenience, danger, obstruction, insult is not defined herein for the provision. Okay. Now, let's discuss the second provision, which is challenged. It is 69A. Now, Section 69A is the power to issue directions for blocking for public access of any information through any computer resource. Now, basically, the officers or central government is authorized to block any public information that is available in the interest of sovereignty and integrity of India, defense of India, security of India, friendly relations with foreign state or public order. If you notice, the grounds are similar to the one contains in Article 19, Clause 2, which is the reasonable restriction for freedom of expression. So on these grounds, public content can be blocked, right? So this provision was also challenged in Shreya Singhal. Now, 79 was also challenged in the Shreya Singhal case, and it is the exemption from liability of intermediary in certain cases. Okay, it says that notwithstanding anything contained in the law, but subject to the provisions of subsection 2 and subsection 3, an intermediary should not be liable for any third-party information, data, or communication link made available or hosted by him. The provisions of subsection 1 shall apply if the function of the intermediary is limited to providing access to a communication system over information made available by third parties, is transmitted or temporarily stored or hosted. The intermediary does not initiate the transmission, select the receiver of the transmission, and select or modify the information contained in the transmission. The intermediary observed due diligence while discharging his duties and also other guidelines as prescribed. And the provisions of subsection 1 shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. Now, basically, this particular section is saying that intermediaries are exempt from the liabilities. For example, third-party platforms like, Facebook, the Instagram, YouTube, these are exempt from being liable if conditions laid down in clause 2 and clause 3 are fulfilled. Now, what is happening in this case, as we have done the provision, now we are coming back to what is being held in this case. So basically, the brief facts of the case goes like that. There is a funeral of a deceased political leader. Okay, so a political leader dies and funeral is held, and the state of Bombay, it is shut down. Okay, so now there are two females who are involved in this case. One who posts on Facebook, she raises some objection with respect to, she raises some questions that why, if the political leader dies, a state should be shut down. And the other, lady in this case, she just liked the post, and now these two women are arrested in Maharashtra. Okay, and they were booked under Section 66A of the IT Act, a law that criminalizes sending grossly offensive messages or menacing messages online. Now, what is offensive and what is menacing, what is of menacing character is not defined. Now, when we use words like, offensive, or we use words like of menacing character, they are insulting, intimidating. Now, one thing that comes to the mind is that how do you define these words? Because something which is offensive for me might not be offensive for you. And also, it is not necessary that everything, which is said falsely, or which is, said in an offensive manner, should amount to you know defamation. It can also be true, it can also be, somewhere existing, and it will not amount to defamation. But then why are we making Section 66A the such vague language? It is containing a vague language in which you can apply your subjective mind, and can, you can arrest anyone, like this, like happening in this case, where these two women are arrested in the garb of Section 66A of the IT Act. Okay, now the country expresses outrage on this arrest, and it was the cry, the outrage cry was that is merely expressing an opinion or liking somebody's post is now an offense. Now, what happens? There is a law student, Shreya Singhal. She goes and files a PIL in the Supreme Court of India and challenges Section 66A for violating the rights to freedom of speech and expression under the Article 19(1)A of the Constitution of India, and says that the law is vague and arbitrary. The terminology used is vague, and there are no clear standards as to what will constitute offensive or of menacing character. Right now, Section 66A, as we have discussed, it punishes sending online messages that are grossly offensive, cause annoyance, they are of menacing character. Okay, they are of menacing character. They they are, insulting. Those kind of words should be, penalized. Those kind of communication should be penalized. Now, the language court is finding is shockingly vague also. Now, what does grossly offensive even mean? Okay, what annoys one person may amuse another, right? So, because these are all subjective words, and whether a person can be jailed for causing just inconvenience on WhatsApp or Facebook, that is what the, misery being raised by the petitioner in this case. So now court is finding that Section 66A is unconstitutional. We will come to Section 69A and Section 79 later, while after deciding the constitutionality of Section 66A of the IT Act. Okay, so Supreme Court in Shreya Singhal struck down Section 66A as unconstitutional because, number one, the terms were undefined and vague. They were subjective. Okay, so the words open to numerous, yes, it open to numerous interpretation. The word is subjective, and therefore it violates a core rule of criminal liability, that people must know clearly what conduct is punishable. Okay, so in criminal law, we follow the strict interpretation rule that what is written only that is punishable. If something happens beyond that, that is not punishable, right? So what does, and when there are multiple interpretations involved for defining a word. So, for example, if I have to define what is grossly offensive and I'm deciding a lawsuit, defining what is grossly offensive, the interpretation that should be adopted by me as a judge, it should be such that, favors the accused, because that is what our criminal litigation is about, right? Now, court is also saying that these words being so much vague, it is causing a chilling effect. A law so broad, it is an umbrella kind of, law, that it scares people from speaking at all, because, like an umbrella covers everything. This law is so broad, and when there is a broadness existing due to vagueness, that may amounts to arbitrariness as well. Okay, now it is an overreach because it is punishing even harmless or unpopular speech, which is going far beyond the reasonable restrictions. Now, how do a person who is commenting that why is a state shut down because there is a demise of a political leader, how is that violating free, how is that, not in how is that fitting in the reasonable restrictions that is allowed under Article 19 clause 2, because the contention that has been taken herein is the shade of Article 19 clause 2, which imposes reasonable restriction. So court of course is not accepting the argument. Court is saying that law in when you apply section 66A, law is even punishing harmless and unpopular speeches. And the principle of proportionality is being violated here. The principle of arbitrariness is coming into the picture, and that is why this law is not a good law. So section 66A is therefore struck down as being constitutionally invalid in Shreya Singhal's case. Now, when we come to section 69A, okay, section 69A basically is, as we have just discussed, section 69A is the power of government to block, the power of government to block the content which can be on the public platform which is accessible to public, right? Now, in section 69A, the court is saying, because the grounds that are taken in section 69A when we were reading it are the grounds which are also matching to the grounds present as reasonable restrictions under Article 19 clause 2, right? So now I'm just scrolling down to section 69A. Just a second. Yes. Now, section 69A is not broad. Now, if you look at the language of section 69A, court is saying that you cannot challenge it because the language is not broad. There are grounds listed, and that grounds are resembling to Article 19 clause 2. They are following the route of Article 19 clause 2, and it is no wrong that government may block online content in the interest of protecting sovereignty, integrity, security of India, public order, and also maintaining friendly relations with foreign states. So court did not agree with petitioner's contention that it violated free speech, but court upheld 69A, saying that it contains adequate safeguard, and the language, construction, interpretation of section 69A is narrow. It is not leading to multiple subjective interpretations. Okay, so there is a detailed procedure, reason to be recorded in writing. That's a provision. Review committee is examining every block order, because 2009 blocking rules are also there, and law is fine. The court is saying, but the law is fine, law is valid when the safeguards in this particular section and supplementing rules are followed properly, right? Now, coming to the third element of this judgment is section 79 of the IT Act. Okay, section 79 of the IT Act deals with the liabilities of intermediaries. So when we were reading the section, it is an exemption provision. Okay, now because it is talking of the liabilities of intermediaries like Facebook, Twitter, etc. Now, what happened originally in IT Act? Intermediaries could escape liability if they haven't initiated or modified content on their own. But 2011 IT rules, when they came, they asked them to remove a content within 36 hours of the complaint. Now, court is also saying that section 79, when on a mere complaint, if the platform is removing the content, the result could be that platform will start censoring. Facebook, Instagram, or anything will start censoring with anything out of fear that they do not go into some kind of liability. So court herein is basically saying that intermediaries are protected, exempted only if they are removing content after receiving a court order or a government direction under 69A. Just because I complained against something I am not finding right and the platform removes it, it is a direct violation of the freedom of expression. Now, this case is, but we might see this case as a construction of the IT Act, of the internet laws in our country, of the cyber laws in our country. But if you go into the depth of this judgment, this is also reflecting the core constitutional value that protects the freedom of speech and expression. And it is also upholding the principles of criminal law, that no one should be punished under a law if a law is written in a vague language, that there can be numerous subjective interpretation of that law. And the judgment is also enforcing checks and balances, that government should follow the due process, especially when the effort is being made to restrict fundamental rights, right? So the reasonable restrictions has to be abide by. A government should follow the due process, and this is what Shreya Singhal is upholding. And it is rejoicing the digital democracy in this case. The case is basically a rejoice to digital democracy. And one thing is that even after Shreya Singhal happening, there were multiple complaints, multiple arrests being done under Section 66A. Now, both the two women who were arrested, they were released, however, but there were, arrests happening in under 66A, and court has to remind states again that Section 66A is no longer a living law, and that it should not be a ground for people to be arrested. Now, this is what was held in the case of Shreya Singhal versus Union of India. If you found this video helpful, please hit the like button, share it, subscribe to the channel for more such cases. And if you need any help, if you want to give any feedbacks, criticism, support, anything you want to communicate, you may drop down in the comment box below, or you may write to us at legaldarshan at the rate gmail.com. Thank you for watching. Please stay tuned. Have a great day.